All right, let's turn to this now. The Socio-Economic Rights Institute of South Africa has welcomed a Supreme Court of Appeal decision upholding a ruling that a 2020 eviction by the city of Cape Town is unlawful. The Human Rights Commission dragged the metro to court following demolitions at the Ethembeni informal settlement in Khayelitsha, where a resident was removed from his shack while naked. SERI Executive Director Nomzamo Zondo joins us now for more on that. Nomzamo, good to have you. Thank you very much for your time. So this is born out of a time when there was COVID-19, and it was an argument, of course, that was brought whether or not during a state of disaster that has been declared, evictions can actually be carried out. And it does turn out the city of Cape Town did carry out quite a number of those evictions in various places, and this is what has been before the court. So two issues were argued, whether or not when the residence is occupied, do you need a court order to do evictions, or when the residence is unoccupied, do you need a court order for eviction? On the first one, the courts found that certainly you do need, and therefore those evictions that were carried out, even though the city argued that there's no evidence to prove that it was the city that was doing it, it was quite clear that the city was in the wrong there.
Good evening, Thabo. Thank you so much for inviting us to have this conversation. I think the one place actually where the parties would have gotten stuck is exactly on that question of whether the shacks, the homes, the houses were occupied. And if they were occupied, it would be clear that our constitution is quite clear that if you're going to demolish a home, if you're going to evict someone, then there must be a court order. Similarly, we are always invited on these platforms to speak about the PI Act, which covers evictions from homes. But the city of Cape Town, actually very much like the city of Johannesburg, the city of Ethembeni, the city of Ekurhuleni, was taking a point that these are not yet homes. That even if they are, firstly, probably they are partially built, which makes it clear that they're not yet occupied as homes. Or even if they are complete, they haven't been occupied as homes for whatever reasons. In fact, many of your viewers would remember that at the time of this incident with Mr. Xolani, the claims from the city of Cape Town was that he had undressed in front of them and had thrown himself into the shack in order to create the impression that it was his home. And the court actually now kind of puts us in a very clear place and provides a lot of clarity on what has to happen. And it says that the moment construction starts, the moment that a pole is put on the ground, the moment a piece of corrugated iron goes across your land as a property owner or your land as a municipality, then you must first go to court before you demolish, which will provide protection for people like Mr. Xolani. Yeah. It will provide protection for people like our clients, the members of Abahlali baseMjondolo, who have been victims of anti-land invasion units, who have gone onto their homes and then said, actually, we checked and we don't believe it was a home. It didn't have the right kind of material, didn't have the right furniture, or as far as we are concerned, we don't believe it is a home. Yeah. And at the time, as you were pointing out in 2020, there was almost a concentrated effort to demolish structures, not only in Cape Town, but in Ethembeni. And in fact, Abahlali baseMjondolo, our client, in a statement that they issued today, pointed out how their own members had suffered during that time. But it wasn't actually about COVID. It wasn't even about the national shutdown, because these actions from the anti-land invasion units had been happening from 5 years before, 10 years before. And even as we speak now, at least for Abahlali, they are still facing challenges in relation to the actions of anti-land, of what is called Ethembeni, the land invasion control unit. So we are here not because of what happened. Oh, I apologize.
I'm saying it will be argued even now that this interpretative approach limits the landowners in a sense.
That is true, but the most interesting thing, I would invite your viewers to look up our press statement on our X page, SERI Rights SA, or on our website, seri-sa.org, and they will read that in effect the judgment is based on a 1973 judgment of the Appellate Division, which explains what is spoliation and what are the parameters of counter spoliation. So in effect, when someone comes onto your land unlawfully without your consent, they've spoliated you out of the land. But if you then want to stop them without going to court, there's an action that's called counter spoliation. And the city of Cape Town was arguing that by removing people like Mr. Kolani, they were exercising their rights in terms of counter spoliation. And the court says counter spoliation provides a very narrow window in that when the person comes onto your land with building material, then you can come onto the land and usher them out or push them out. But the moment that they start building something with the intention to create a home for themselves, they actually then already have possession. And our law actually guards against the violence of the first spoliation, which is by the people coming onto your land, but it also guards against the self-help and the violence of the second spoliation if you then go and remove them, as the city of Cape Town did, without a court order. And our law, as far back as 1973, was that if you find yourself in that situation as a property owner, your job is not to take the law into your own hands and to create more violence. It is actually to go to a court and say, here I am, I'm the owner of this piece of land, this is what has happened to me. I need the court to order that this person vacates my land.
But I'm being deprived already of my possession, and now I need to spend money on court action. Am I not being deprived again?
But that is the law, because remember, all of us have feelings, all of us have things that we lose. But the point of government is to regulate so that we can live peacefully with each other. So this rule is against self-help in order to make sure that we actually have in an environment where violence is minimized. Where people, because in effect what you have here in this case is you have the municipality being the judge, the jury, and the executioner. Because they come onto the land, they are really the complainant. They say you've moved onto my land without rights. And then they remove you, and you have nowhere else where you can actually say, wait a minute, here I am, these are my problems. But we've made it even more, I think, in the intervention that Abahlali brought, they brought another aspect, which is now brought by the Constitution. So, Yeko versus Ghana is 1973. But Abahlali says, once you get to 1994 or to 1996, you now have a constitution that guarantees the right to housing. You have a constitution that guarantees the right to dignity. And that constitution puts an obligation against the municipality to actually provide for the person who's moved onto their land unlawfully. So the relationship is not simply a relationship of a landowner versus someone who's spoliated them, but it's a landowner who's also a duty bearer who must make sure that people have access to housing. And in acting in any way, they must act reasonably because the Constitution demands that of them. But secondly, in any event, whatever actions they take, they must further your right to housing, which means that in the exchange between Mr. Kolani and the city of Cape Town, there should have been an inquiry of, okay, Mr. Kolani, how did you get here? And if you are going to move from here, what's going to happen to you? And then find a way to intervene in a way that kind of protects the rights that he already has.
Right.
Because you are the state, you are the municipality, because you have this obligation.
So then the other relief category that was sought is to determine how companies, demolition companies, security companies, should determine whether structures are occupied. What was key coming out of that?
Look, so in fact, in the case, I hope I've explained that the case was brought by the Human Rights Commission. I think you opened with that. There were communities that intervened. In fact, the EFF intervened a party in the litigation as well. And the city of Cape Town had a position. And the city of Cape Town's position was, you must trust us. Trust that we as the municipality, when we go onto the land, we will look with our eyes and we will decide if it's occupied as a home or not. And if it's occupied as a home, we'll go away. If it is not, we will then demolish and remove people. But even in this case, and the Supreme Court of Appeal points out that in one of the circumstances there was an eviction, and I'm using that word almost for the first time now. There was an eviction from a piece of land that wasn't even owned by the city of Cape Town, where the city of Cape Town had taken it upon itself to go and evict people and demolish structures there, and had then gotten the consent of the property owner after the fact. And then it was clear that actually in that community, people had lived there for 3 months. Therefore, they were clearly in occupation. Clearly, there was a need to get a court order to remove them. But now the city didn't even have a legal basis to remove them. And in all that you had was to say, we'll trust these officials. Most of the time, those officials are junior officials, right, who know probably very little about the law. But secondly, as has come up over and over again, are not sensitive to our human rights framework, are not sensitive to the dignity of what they're dealing with. In fact, again, Abahlali, our client, points out that they've lost 2 members who have been killed in such operations. In 2020, in the time that this happened, I think just from April to probably September, not only were Abahlali members victims of demolitions, but they had their belongings burnt. They had their food thrown on the ground by such officials. And the court is pointed that actually what you then need is a court who's going to guide these junior officials on what they should do. And that's why you can't simply act as the municipality. You must go and get a court order, which will be clear for you what you must do. And I'll give one example. The court points out that the residents or the homeless who attempt to build have a right to have their belongings and possessions protected. They have a right not to have those confiscated. And normally in other circumstances, like in informal trading circumstances, when the police come and confiscate your goods, they itemize them and they say, I've taken 10 bananas, 20 apples, 50 pears, and here is a receipt. You can come back and claim this from me. But in these instances with the anti-land invasion units, one, as I've said, either they burn the building materials, the furniture, the clothes of the people who moved onto the land, or 2, they simply pack it away, put it on a truck and drive away with it, without differentiating what belongs to Thabo, what belongs to Nomzamo, what belongs to Spoliation. And a court-guided process would at the very least guarantee that.
So what happens now in a case where a tender is issued, because one of the relief sought was to interdict the demolition tender itself? Well, I mean, it's been carried out. What is the legal effect of that?
Look, so the challenge to the tender itself was dismissed. But what is important, and I think what is important for Abahlali, and I imagine for the residents that were part of the case, is that even if there is a tender to a security company to carry out the work of the anti-land invasion unit, that work would be guided by a court, number 1. But number 2, an important aspect that has been lost because of this perceived power to remove at will and with force and without any consequences, is that there hasn't been any engagement between communities and the municipalities in these circumstances. And if municipalities must bring a court application, they are then forced to identify who are the people that they want removed. How do they come to get to be on the land? 3, attempt a negotiation with them, which actually changes the relationship and provides for a shift in power between municipalities and communities in a way that I actually think will be very constructive. I think in our experience as SERI, and I think even Abahlali's experience, whenever people have been removed forcefully by municipalities with violence in this way, their only protection is in numbers, which means that actually these occupations grow and become larger. Whereas if municipalities were to go and negotiate with residents to say, we know that you've moved onto this land, this is the information that we have, we know there's 20 of you now, we don't want you to be here, but since you are already here, how do you make your life comfortable here? And how do we work together to protect this land? Because we've targeted it for another housing project, we've targeted it to build a school. Yeah. That will create a very different environment. And that's important, Thabo, because of where we are as a country. We are not in a situation where the majority of the people in this country can afford to buy land for themselves. Those who actually qualify for housing assistance and subsidies are, in fact, in relation to the city of Cape Town, it's in the judgment as well. It would take you 70 years to actually move up the housing list. 70 years. So possibly you could be born and die before you actually get to the top of the list, which actually means that your chances of getting support for housing are very minimal. And two, your own ability to buy that for yourself is also impossible, which means that actually people are going to be pushed into this circumstance. So we have to deal with it in a way that says, okay, we don't like it, but how do you manage it? How do you make it work for everyone?
The other important aspect here, I suppose, is the question that has been raised about the conduct of the South African Police Service. The police would have said, look, we are just merely here to observe. It's the sheriff that carries out the evictions. What did the court find should be the behavior of the police in such instances?
Look, so I mean, in this case, for instance, fortunately, it wasn't dealing with the issue where there's evictions and there's sheriff, but it was dealing with, during the lockdown, you had the SANDF, you had SAPS, you had the Metro Police, and in those municipalities that have special vehicles to attend to land invasions or land occupations, you had those teams plus private security carrying this out. And unfortunately, and maybe fortunately, the court points out that their actions have been demeaning, have been dehumanizing, have acted with a complete disregard for the dignity of the people who are in these circumstances. And the court calls it out and says, actually, this should not be done. Again, going back to the intervention of the EFF points out that the kind of actions that we've seen carried out by these anti-land invasion units are actually spot on to what we saw pre-1994 with the apartheid government. In fact, one of the judgments that I think we had raised is a judgment from the Johannesburg High Court in Stretla, where the city of Johannesburg again was called out for having acted in a way that we should not be seeing, that there is a need to treat our people, poor people, homeless people, even if they occupy land unlawfully, with dignity. And for some reason, that has been completely missing in the way these anti-land invasion units have acted. And almost every removal is not only met with people just losing their homes, but there's violence, there's property being lost, and there's a complete disregard for their humanity.
And so, Nomzamo, what's going to happen now? I mean, is the city now expected to return the materials, pay back the 2,000, the sum of possession that could have been lost by some of those who were evicted? Or are you gearing up for another court challenge where the city is going to appeal this?
So there were two parts to this application. The first part, which dealt with the issue of compensation, was finalized first, and it was the Supreme Court of Appeal. So the Cape Town High Court had ordered compensation, but the Supreme Court of Appeal, in another case, not this specific hearing that we're dealing with now, had reversed that order of compensation. So there is no issue of compensation at this point for these communities that are involved in this case. But the city of Cape Town has commented, one, welcoming the judgment, firstly because it keeps intact the counter-spoliation as a possible defense. But they've also said that there are parts of the judgment they're unhappy with. And we assume that it's the bright red line that the court has provided, which is to say, if you need to bring a hammer, if you need to bring a bulldozer, if you need to remove anything, you need to have a court order. And we suspect that that's the part they're unhappy with, and that's the part that they are likely to then bring on appeal to the Constitutional Court, which is the next and the last court up the ladder. I believe that our clients, Nomzamo Zondo, would want to intervene in the Constitutional Court's hearing as well, because they believe that this is a crucial matter for their members. And again, we hope, and I think we probably expecting that the Human Rights Commission would also oppose such an appeal and would participate, because the position as set out by the Supreme Court of Appeal provides the most protection to people who are landless. It also makes sure that people who should be covered by Section 26(3) of the Constitution, which guarantees the right not to have your home demolished or to be evicted without a court order, do not have that taken away from them by simply labeling them different. And so I think if we do end up before the appellate courts, chances are the people that have participated in the hearing in Bloemfontein and in Cape Town would be participating. And possibly maybe other municipalities would come and bring their own perspective on this. I think for Abahlali, it's important because they actually do want to engage with eThekwini, with Ekurhuleni, definitely as the two, and Johannesburg, as the three municipalities where their members have had this challenge, and saying to them, look, you've seen the judgment. You've seen that actually for the longest time, you didn't have this right. You should not have been doing this. Please give us your undertaking that you will not do this anymore and that you will approach your court every time. It might then mean that in the near future, there's a challenge to the actions of the units in those municipalities as well.
Nomzamo, appreciate your time. Let's leave it there. Nomzamo Zondo, Executive Director at SERI, there on that latest development as far as the matter, the City of Cape Town versus the South African Human Rights Commission, based on those evictions that took place there at the Ethembeni informal settlement.